Hi everyone, welcome to episode 97 of the Immigration Lawyers Podcast. It's been such a wonderful few weeks with the increased amount of episodes I've been putting out and the LinkedIn page, Immigration Lawyers Toolbox LinkedIn page that was created, the amount of viewership and attention and comments and just general growth of the community has been extremely large. So I want to thank you all. If you haven't followed the Immigration Lawyers Toolbox page, please do. I've added extra stuff in there like new job postings that don't always go on the immigrationlawyertoolbox.com website. Sharing other people's videos that are interesting information about immigration, and also putting clips of the mastermind, the Q&A mastermind group for immigration attorneys and general attorneys I've created, where I talk about business marketing and business development, as well as areas of immigration law that are a little confusing, and helping to explain them to practitioners and have a discussion about how they work. So we're going to have another QA mastermind group on the last Friday of this month in June. It's going to be at noon Pacific time, 3 p.m. Eastern. Just email me at info@immigrationlawyerstoolbox.com to RSVP. Please do so soon, because I like to keep the group small so it's a better group to communicate with and talk about and discuss. So there's a cap on that, but I'll be happy to have you part of the group. It's going to be a fun time. Also, as a reminder, there's an Immigration Lawyers Toolbox YouTube page, and if you just type in Immigration Lawyers Toolbox in YouTube, the page should come up. That has also clips that aren't on the podcast or maybe aren't on the LinkedIn page, but I put there as well. So there's just a lot of content information I'm putting out, both on business development and on immigration legal education. That's going to be helpful, and I'm going to continue doing that. So thank you so much for listening, and without further ado, we'll get it started. Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted, and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. So this is going to be another tips and legal information episode for practitioners. I'm going to be editing, cutting out major ones, and posting it on LinkedIn and YouTube and such, so you can catch shorter versions if this one goes so long, because I have around 7 pages of notes to go through. But just to give it a start, and I'm not going to go too much into news and stuff, but the USCIS director, Francis Lee Cisna, was forced into retirement or resigning, and it's not clear who his successor is going to be. There's talk about a gentleman named Ken Cuccinelli, who is a hard-line immigration, anti-advocate, no, the opposite of advocate. And this has even gone so bad that the president of the American Federation of Government Employees Union, representing USCIS, actually had a quote in CNN saying, the resignation of Francis Lee Cisna as director of USCIS and the possible appointment of Ken Cuccinelli as a successor spells the end of legal immigration as it currently exists. This is Danielle Spooner. She goes on to say, it has become clear that the goal of this administration is to end immigration altogether. How better to do that than by appointing as the leader of USCIS someone who knows nothing about immigration, adjustment of status, or naturalization, and whose sole purpose is to destroy the agency that grants these benefits. So the hardline attitude goes into the employees of the agency as well, and how they're dealing with them. The union right now is undergoing negotiations and talks to actually renegotiate the contract. The government is forcing them to open up around 24 amendments with regards to all aspects of a USCIS employee, the group union contract they have with them. So that's a contentious time in the agency itself, and shows how much pressure they're under. And there's more to it than that. They're forcing them to give up their badges or not give new USCIS badges to their officers, and more stuff like that. So internally, agency, there's a lot of stress. At the same time, there's a large volume of new applications coming that are just building up with the backlog, as you know, with the delays. So it's a very depressing situation going on within the agency. As a consequence, we as practitioners and our clients are also feeling the wrath. So there's an all-frontal assault and it's an all-out attack really on the system. Now, it's surprising that they would force Francis Lee Cisna to resign, because he was a good technocrat for the system in their agenda. So I'm not sure they understood how well they had it with a person that knew the system as well, but we'll see what's going to happen next. Now, further going to the administration's crackdown on the immigration system within the courts and the asylum system, there was a BIA decision that said that meritless affirmative asylum cases that go into immigration court will lead to case dismissal. So this is a really bizarre situation. Sometimes there are people who are in the U.S. who don't have status but could potentially take advantage of cancellation removal. They just have to be in removal proceedings to be able to request that benefit for an immigration judge. But DHS won't issue an NTA for them to go there. So one tactic which was used, and I never use it because I don't have these kind of cases. And it seemed like some agency memos in the past said it was even okay to do this, but to file an affirmative asylum claim, get it denied, and request that an NTA be issued so they could enter the immigration court that way. And I actually remember being at an asylum liaison meeting once, and they said you could do that, I think, Lee. So internally, the agency had accepted this methodology. Well, one practitioner did this. DHS said, no, we want to terminate the case and not pursue it. This is a person that could have been a removal and kicked out, but they had a good cancellation case. DHS said we'd rather them just stay here illegally rather than to be able to use cancellation or removal. So this case we looked BIA, and they said these meritless cases permit a judge to terminate the case at the request of DHS or probably on their own and take it out. So it's a weird result just for the sake of not giving any benefits to push someone out of a removal proceeding just so they could say, without status in the U.S. These are the bizarre things that happen when there's an agenda in place with the immigration system. And when you look at military people that are in the military, foreign recruits, they've gone strict as well. A federal judge was able to help out those who are in the MAVNI program. These are foreign recruits in the military that want to apply for U.S. citizenship. And there were some harsh policies that were going to them that were forcing them out. But there's also word on the street is that soldiers that were naturalized are failing their background checks or are being kicked out because the administration or the agency, that agency is fearful of some sort of having these people within sensitive areas of the government. So it's a difficult time. Even immigration within the military, it has gone difficult, although courts have been pushing back. Now, speaking of the courts themselves, the Department of Justice through the OIR issued a few-page PDF that didn't have any citations. It wasn't very formal or proper, called discussing the myths of asylum process in courts, and it really was a propaganda piece, and it was very surprising that an agency, a lawful agency, would issue something like that, and it really took off the veil of any partiality within the system. There was pushback from former immigration judges, and then other people pushing back against that on both sides. But if you haven't reviewed the document, it's good to take a look at to get an idea of where they're coming from with regards to their perspective on immigration and the counter discussions that go back and forth. It really is kind of sad to see a government agency put this one-sided document. It was better that they didn't do that, but this is the kind of things to expect under this Department of Justice. Now, the president has been pushing a lot of tariffs. Obviously, there was a tariff that he wanted to issue against Mexico unless Mexico cut down on migrants moving through their territory to come to the U.S. And it seems like some sort of deal has been reached with Mexico. But when you push that further, if you look at the tariffs that are happening on China and Iran, these are financial transaction tariffs of sorts or blocks. These are all going to affect our cases with regards to H's and L's that have on the form I-129, foreign transactions or foreign or the dissemination of technology abroad. For example, with the ban on with the government's crackdown on technology from Huawei, the Chinese telecommunications provider, using their technology or transferring within or working with some company that has that could create problems and lead to a denial. So not only will you need to have an immigration attorney on some of these cases handy, you'll need someone who's familiar with these sanction-related activities to see if this technology is something that's going to be troublesome with this information. And so it creates more work for what could be a simple L or an H. You got to be mindful of not falling foul of that or giving guidance that you don't answer on, guidance that you don't know the answers on for these issues that come up for L's and H's. Now, there's been some form changes. Form I-407 has been changed. That's the renunciation of the green card form. There's also been an update on Form I-539. This is the extension of status, change of status. So what's important is they did add a biometrics version of that for the people requesting it. And also, there's a supplement to it for each child. Instead of having one fee that just covers the parent, each child has their own form as well and their own biometrics fee. So when you're submitting these applications, be mindful of the fee structure that happens with it, because it can be different than what it used to be and cause a file to be sent back. An initial thing is if you look at the instructions on Form I-539, it talks about filing a bridge application if you're waiting for a change of status. For example, in the past, if you're doing an F1 student visa change of status, you file for the F1 change of status I-539, but you also needed to file an I-539 for a B2 tourist visa extension that acted as a bridge. Now it gets a little more complicated than that, and I'm not going to get into that here. But if, based on what they're writing, if you're going to do change of status to an H or an L or something like that, you also, as a primary applicant, maybe the dependents also need to file for a bridge too. And that gets a little troublesome because in the past that wasn't necessary, and I'm not still sure it is, because when you do file for change of status, you're in an authorized period of stay according to agency memos, and once the case is approved, that approval goes back to the date of filing. So is it necessary to pay an extra fee for a B2 extension? I still haven't got word on how that is. I'm trying to find that out, but that's something to be very careful of when you're filing these kind of cases. Now, taking things to a more international level, with regards to marriage green card cases, sometimes spouses want to get married overseas. Now, the requirements for getting married overseas, just the status, the civil status of it, not the immigration aspect, is really simple. If you're going to get married in the U.S., the rules here are pretty straightforward in most counties. They just go and get married. But when you get married abroad, there's more stringent standards. So you have to be mindful of this. For example, there are some countries or some cities or provinces or jurisdictions that require the foreign spouse to be within that jurisdiction for at least 4 weeks, 6 weeks, or something like that. So if you have a client that's going to do a destination wedding, just get married, come back, and then file for consular processing at I-130 and all that, you got to be careful if they go fly out and they want to get married, and all of a sudden the city hall says that, well, you got to wait here 4 weeks until you get married, and that could ruin everything. So it's something to study beforehand to make sure you could get married in that fashion. Another aspect of it is that some foreign jurisdictions require that you provide a certificate from your home country that you're single. Now, the U.S. doesn't really provide this kind of document. You could ask for the U.S. Embassy to give something like that. It's not official, but it's just something that says we believe they're single, or some sort of certificate like that. That's not official. It's accepted by many places, but that's something to be careful of. Now, you have some countries, I had a colleague say this, and I haven't checked for myself. I haven't been able to find out and corroborate this for myself, but for a country like Iran, if they're going to issue a single certificate for the purposes of getting married abroad, you have to state and write that the foreign national that they're marrying is going to change their religion to the religion that you have. So it's kind of these nuances that each country has to be careful of when we advise our clients just to get married. If you want to get that extra level of service, knowing the details of this kind of stuff could be very helpful. Now, keeping in line with the international aspect, the National Visa Center has been having a lot of problems for practitioners recently, and there's a long list of just Department of State issues that I have. Well, first of all, I had a case where we were trying to pay the fee. We were trying to pay the fees for the case, and as you know, when you're doing a consular processing for a family case, there's a two-part fee structure. First, you pay for the affidavit of support, and then you pay for the civil documents section or the application itself. We were able to pay the affidavit of support fee with no problem, but the link and the box for paying for the application fee wouldn't be unchecked, and we had to go back and forth until they were able to finally make it available for us to pay it, which pushed things back a week or two. And that was just annoying that happened. That should have been automatic in the system. Now, I have another case where once we submit everything, they said that some documents were missing, but everything was submitted, it was proper, and there was nothing we could do to fix or add anything because the system was locked at that point. So I had to contact them back and forth to fix that until finally they said, oh no, everything's ready, just wait for an interview notice in the future. Now, I was happy with that, but when I looked at their email response, I saw that they had changed the category for the applicant from the F2A category to an F3 category, which means the time of the application was going to take forever. Even though it's not valid, they were still in the F1A category. So I emailed, this is the next problem that happened, I emailed the NVC attorney at dos.state.gov, I believe it was, the special attorney email that we have where we could communicate with them. Waited a week, got no response, sent it again, waited a week, got no response, and then I learned from colleagues that this email address has been discontinued. And we had received no notice of this, and this was the primary way that attorneys would contact with the Department of State. So that NVC attorney email apparently doesn't work anymore, and you have to go through the general contact page that the Department of State has for these kind of issues and fill that out. So I filled that out, sent it, still no correction on this case status. A week goes by, or 10 days, I submit it again, still no response. So my worry is that they put this case, which should have an interview coming up any day now, into the F3 category, which means we have to wait another 7 years, and they're not correcting it. So these are the kind of problems that are happening that are pretty substantial. Putting aside the annoying issue of that new word capture system that they have, where you have to put in, additional, word capture, letters and numbers to get it in, and many times it takes 4 or 5 tries to actually go in for some reason, even if you correctly type out the letters and words that are in there. So that was something that was very obnoxious, and just a lack of communication was really difficult that they did something like that. Now the NBC and the Department of State in general for the application DS-160, DS-260 have added what used to be on form DS-5535 for extreme vetting onto the forms themselves, the main applications, asking for social media handles for the last 5 years for a set of different websites and social media outlets. So that's something to look at. But other issues come. Sometimes you might not remember what your handles were maybe 4 years ago. You don't use them. Sometimes you create multiple social media handles because you want to check something out, but don't remember. If that's found out later, will that be considered misrepresentation or fraud? Will that create any issues? So it's kind of tough when they put these things in there. Now, the Department of State did issue 2 reports. One was a liaison report directly between AILA and the Department of State, and another between the Kentucky KCC, Kentucky Service Center, or that wouldn't be it, but the processing center in Kentucky that deals with diversity visa cases and deals with some sort of electronic paperwork to happen. Now it's a must read. I really recommend going through these, but I have some notes here I've taken from some interesting points that were in that program. For example, at the KCC, they handle the change of status or consular processing for certain non-immigrant visa categories, such as Ls, where you have to send double copies. One copy stays with USCIS, a second copy gets sent to the KCC for consular processing in the future. They say double copies are needed because if you don't send a double copy, the consulate won't be notified. But in the future, it seems like in the near future, they're digitizing everything so that finally that second copy isn't needed, which will save clients a lot of money, make the postage box much smaller, and much less hassle because it's many times practitioners forget to send the second copy. And along with that, they say if you have an RFE submission, you have to send a double copy for the RFE as well. Sometimes people forget to send that. Now, I've seen colleagues forget to send the second copy and go consular processing. It's been fine without an issue, even though they're supposed to have sent that. And also what's weird is, let's say you do change of status in the U.S., you only need to send 1 copy because you're not consular processing. But if you leave the U.S., you need to get a visa to come back in. In that case, there is no second copy, so what difference does it make? I don't know exactly what that is, but these are the kind of issues that practitioners have to know as nuance to avoid problems. On the NBC side, there were a couple of things mentioned in this report that I want to talk about. Last program, I talked about how tax transcripts are mandatory now, not tax returns. The NBC, in their statement with a liaison, said that no, regular tax returns are still acceptable. However, in practice, this is not true, and best practice is to always force the clients to get the tax transcript and submit that for the application process. They also said that all consulates are beginning to accept the digital version where we upload documents as opposed to mailing them, unless your case was approved and consular processing started before that specific consulate changed. But at this point, all of them will start having new cases require the upload system for documents. They also said regarding I-797 approval notices with, for L1s, for example, again, you don't need the original approval notice when you go to the embassy or consulate because they'll see in what's called their CCD system for the I-129 verification. But they say, and I'm not sure how this works out because I've had this issue, but some consulates will require the original notice to be able to schedule an appointment, so you may need that on a case-by-case basis if the consulate requires it. So, it's a hassle sometimes if the beneficiary is overseas to mail them an original notice. There's cost and time and delay for that. It might get even lost in the mail. But on a case-by-case basis, that might be a necessary thing to do, though I don't think I would do it most times. There's also been a change to the FAM where in the past, panel physicians, when they were going to grant an immigrant visa or if a medical checkup was required for a non-immigrant visa, they would submit directly to the embassy or in a sealed envelope but not give a copy to the person, the actual beneficiary of the visa category. And it seems that they changed the FAM and had tip to Stephen Heller in the UK who noticed this, that the Foreign Affairs Manual, the FAM, says that the applicant, if requested, should be given a copy as well. Some doctors are hesitant to doing this, and you should push back. I have this issue with civil surgeons in the U.S. as well, would I demand that they give a copy of the medical checkup to us and they don't want to give it or want to give partial versions of it, I frequently notice that they have missing check boxes or they sign the wrong parts and create problems later on when we're at the interview for adjustment of status, for example. Now, these foreign doctors are supposed to give it. If they don't, you got to also remember many countries themselves have regulations that forbid a doctor from not releasing personal information to the applicant themselves or the patient themselves. So if you're in Canada and a doctor says no, it's against their ethical laws for doctors not to give a copy of anything they do to the beneficiary, the patient, or the applicant themselves. So they can force that issue on them. Normally it's not needed, but it's good to see what they wrote in there. One thing to note is if there's something bad in their checkup, they're going to transfer the information directly to the embassy, so it's not like you can hide and rip it apart in those kind of cases. Now, the travel ban. A lot of Department of State travel ban information has come out. A hat tip to Shabnam Lutfi, who's had a lawsuit against the government. A lot of new data was released, and essentially just goes on to show that the travel ban waiver system is a sham. And also looking at the statistics of how many people are hit by the travel ban, it primarily, almost exclusively, is Iranian cases. So this is not a travel ban per se, it's an Iranian ban with some other countries thrown in the mix. I got to really challenge people who call it a Muslim ban because Saudi Arabia, Pakistan, it's places in Southeast Asia that are, Malaysia, I believe, that are Muslim-dominant countries. In Africa, Nigeria, these countries don't have the ban. And this is primarily an Iran, warfare type trade embargo situation, a people embargo situation that's happening, and they threw in some countries that are potential allies with Iran or proxies that exist in there like Yemen, Syria, and these kind of countries. So it is primarily Iran ban, and that's a very sad thing because so many Iranians want to come here. And one thing I want to get into later, but I'm going to get into now actually, is the RAND Corporation. Now RAND, R-A-N-D, is a group in Santa Monica that for the last 50 years has been an appendage of the government that does intensive analysis of political economic situations and advises the president and the military and the like about what to do behind the scenes. They're privy to a lot of top secret information. They have big minds and big computers that come together and they have a lot of analysis. And one of the reports was about how to deal with Russia. And one of the conclusions they reached in their report that they did about how to deal with Russia was that, quote, another way of destabilizing the Russian economy in the long run is to encourage the immigration of qualified personnel, particularly young Russians with a high level of education. So on a strategic strategy for military and diplomacy purposes to undermine Iran, if that is their goal, increasing immigration from Iran of students, of educated people, of their wealthy people, of their talented people, further destabilizes the regime as it is and hurts them. So the idea of a travel ban only serves to increase their power and hurt us. And it just goes to show this is backwards ways of dealing with immigration policy because of lack of thought. When even their own think tanks are saying that's the way to destabilize, and that's what we've been doing in the U.S. for the last 50, 70. And every year, decades go by since post-war period. Our method of destabilization was taking a brain drain from other countries, and to not do that with things like travel ban is just really sad. And thing to know, travel ban countries list was started before this administration. This was during the Obama time that this was originally created, which affected the ESTA or the visa waiver program. Now, I might have made a note about this in the past, but the travel ban still affects Canadian lawful permanent residents, even if they landed in Canada as landed immigrants. Travel ban still applies to them unless they have a Canadian citizenship, and at that time it would be different. Although it is a positive consideration if they are a Canadian green card holder for being able to maybe get a waiver for the travel ban, but as you know, the waiver is this mythical thing that pops up every once in a while, and you hear about people getting it, but in reality it doesn't seem like it's something available to everybody. Now, another last funny thing I want to talk about, this liaison report that was from the Department of State. One of the last things they talked about, Ayla had asked, the Department of State website includes a document entitled Calculation of the Adjusted Visa Refusal Rate for Tourists and Business Travelers under the Guidelines of the Visa Waiver Program. And Ayla says, the link is broken, can you send us the correct link? And the State Department goes forward and says, yeah, I'm sorry about that, but here's the link, http://travel.state.blah. Here's a link you could go to check this kind of information. Well, if you go to that link, to the State Department's link, and says this page can't be found. So even in their own answers, they don't even click on the link to check on themselves. So these are the kind of issues we're dealing with the Department of State. It's just basic administration stuff that's having problems. And it sucks because the Department of State is so pivotal in the process for immigrant, non-immigrant visas. And just even the simple stuff's not happening. I understand if there's national security stuff, if someone has criminal history, blah, 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 all that kind of stuff. But if they put the wrong category for a non-immigrant visa or a visa category, if their links don't work properly, these are the kind of stuff that someone is sleeping on the wheel, or hopefully it's not bad intent that this level of incompetence is happening. These are things that should be fixed and much more expected, because the Department of State people, I've been interviewing consular officers recently. They're on the line, and the management. I've had a problem with the diversity visa case because the application last year for diversity visas all of a sudden shut down. My client was plugging it in and it stopped working. And I called the embassies, called everybody, emailing everybody, no one gave an answer. Like, there's this email that some embassies have, it's like usvisainfo.com/Australia or whatever. When you email one embassy, it goes to another one, and another one says, we don't know what you're talking about. So I was going in circles, and the client was freaking out. So I just went down the call list of the Department of State and contacted the head of the diversity visa program and just told him what happened. And in 2-3 minutes, he's like, don't worry, I'll fix it. And a couple days later, it was fixed. So there are people who want to do it, but this bureaucracy has just gotten out of control, out of hand, or I don't know what's going on. But these kind of issues shouldn't happen. It's really ridiculous to have these kind of problems. Again, if it was major substantive problems, I understand. Sometimes things require additional analysis. But offering an email where the link doesn't work, that's sad to see. Now, with regard to visa categories, there's a report that came out with USCIS about H-4 visas who get work permits. There was around 120,000 of these cases, and interestingly, 110,000 of them were Indian cases, Indian nationals that are requesting the H-4 work visa. So it really just goes to show that this is primarily an Indian national issue, this H-4 case. So it's kind of crazy to see one category dominated so much by one group. The next group was China, 7,300, and then from that 600 for Philippines. So that's kind of crazy that happened. Now, another interesting thing that did happen for the visa bulletin is the F2A category for filing dates is going to be current pretty soon. It jumped a year ahead, so that's gone fast. And also Philippines EB3 is going to be current soon as well, it seems, from what they're telling us. So that's really interesting. F2A, if you could file, if you could file an adjustment package with the I-130, that would be tremendous. Now, with regards to USCIS, there's some new things we've been seeing. One is during interviews, they're more and more asking for people that were on student visas to provide transcripts, degrees, and proof of education, I-20s, where it wasn't required in the past if you're adjusting status through marriage to a U.S. citizen, for example. Especially because U.S. citizen marriage forgives a lot of visa violations in the past, like if they had dropped out of school and the like. But they're putting more emphasis on that, even though a lot of times it's not needed. It's partially maybe because a lot of these schools have been coming out as fake schools for F1 meals and stuff, and they're trying to crack down on that. But that might be the case. But that's something to be careful of. So when you are doing an adjusting interview, have clients bring the right 20s, transcripts, degrees, to be able to talk about the education that they received. Now, the interesting thing is, if you file now, especially with the NTA memo, if you in the other memo about missing documents in an adjustment package, for example, you forget a birth certificate or affidavit of support and the like, they're going to take your fees and deny the case. There was one case on a list that they discussed where this happened, and the poster had asked, should I just file a new package or should I do a motion to reopen, reconsider, pay that fee? And the typical response is that it's faster to just reapply for adjustment, correct the documents, because it takes a long time for the I-290B motion to even be opened and looked at and stuff. And that was a consensus for a lot of people. But then someone said that I had a client that came, this is what they said in the listserv, and I told them the two options, and we just did both. And within like a few weeks of filing the I-290B, the case was reopened and a new appointment was scheduled. So it was surprising to see that happen. The typical answer was not that to file a motion to reopen, but that works as well. And it's kind of weird because if you forgot to include the affidavit of support information, is that something you could do a motion to reopen on? It's not a legal issue, it's not a factual issue, but it worked. And so that just goes and increases the confusion of what is going on with these applications, what is the proper way to go, and without having clear answers to how this works. Now USCIS's relationship with AILA has gone bad. Apparently AILA had posted something that was in the public domain on their website. It offended USCIS, so they canceled all liaison meetings and communications. There wasn't much value coming out of these communications, but you got to keep the the communication alive and open. It's kind of sad to see that happen. Hopefully that can be fixed. Now, one note is I've always paid attention to different field offices and how they do adjustments, especially because my office is national. I take cases throughout the country. I really want to know how strict they are. And in most jurisdictions, for example, if you're doing a marriage adjustment case, they have the couple go in there, they talk with them, they get out. But some jurisdictions like Boston, they force every interview to be a Stokes interview. They separate them. So I was interested and asked around, and one of our listeners told us that in Cincinnati, this is North Kentucky where they see their cases, they do separate most couples and do a Stokes interview for the initial one. So there are a couple of jurisdictions that require separation of the couple for the interview. It's something to be prepared for. Now, one thing another listserv poster had said is that they were talking to a level 2 supervisor at USCIS, and they asked about, this inquiry when case processing is taking too long and what's going on. And they said that every time you make a case processing request, another officer has to pull that case out of the file, look at it, and return it back into the file to give you a response. And that pulling the case out of rotation and bringing it back in will cause extra delays in and of itself. Now, I'm not sure if that's true or not, but that's something to be mindful of if you're doing a lot of these requests to see what's going on with cases, because frankly, a lot of times the answers they give you are just like, keep waiting. That's what I've been getting. So the keep waiting answer doesn't really help much. So if it's possibly going to cause things to take even longer because they pulled out a system, that might not be the way to go. Another thing about expedite requests is I had this issue. Usually I do file expedite requests when someone wants a work permit or advance parole. We have documentation of the need for it. Call the 1-800 number and request it to be expedited. I did one recently right after we received the I-485 receipt with the I-130 I-765. Submitted it, faxed it to them, our need for it, and we got a response that said that because the biometrics appointment has not happened yet, we can't review this. So one thing to note is if you're going to do an expedite request, make sure the biometrics appointment happens before you make the request, so you don't get a follow-up that says we got to wait for biometrics to happen. Now, you don't actually have to wait for the actual appointment date to happen. If you get the appointment notice, you could go immediately and say, I'm just coming in early. And in some rare cases, back especially when InfoPass was available, you could ask the field office, to once you get the receipts, for example, for them to issue a biometrics appointment so it's in the system and you can hurry this up. But getting InfoPass appointments is hard. It's going to require you to go downtown or your local field office to talk with an officer. It's going to jack up the fees because of the amount of time that's there. But those kind of possibilities somewhat do exist, so it's something to look at. Now, along with filing these family-based adjustment cases, the public charge issue has gotten really serious, and it's not just adjustment, mostly for consular processing. President Trump did sign a memorandum requiring immigrant sponsors to pay for social services. So this was a requirement that's always been there when you sign as a joint sponsor for the I-864, that the public agencies could pursue you for fees. But I think this is going to be their new push to make it an affirmative kind of push to crack down on this kind of stuff and to charge people for it. Another problem that happens is when people get benefits, a lot of times there's mean tested benefits, which says you have to show how much income you make to get the benefit. And when you're a lawful permanent resident, in many cases, especially a new one, you have to include the income of the sponsor, joint sponsor, as your income when making that calculations. But a lot of times people don't know that that's a fact, or they don't just include all the joint sponsors and the like. So what happens is their filing for these benefits is mistaken, and later on, especially now with this kind of push during naturalization, if they look into it, that could be a problem for misrepresentation or getting benefits that you weren't supposed to, at the very least requesting that this money be paid back. Now, for I-864s at the embassy, there's more and more issues you're hearing of people with proper sponsors but still not being approved because of public charge, or using the asset requirement or assets possibility for showing income availability of the sponsor instead of regular paycheck income. Having problems with those. Myself, if I'm dealing with the embassy, I won't use assets. I only use that for adjustment of status kind of cases. Now, another interesting thing is I was doing a follow to join where the principal applicant or beneficiary adjusts the status, and we're going to bring a family member overseas in. And I was looking at Form I-864, and I realized there's a part where it asks if you're doing to follow the joint to fill in the person's name there. But when you look into the instructions, it says that, but then other parts of the instructions say you don't need to write someone's name. And then the Foreign Affairs Manual for DOS and the Adjudicators Field Manual for USCIS, it says don't write the follow the joint person if they're coming after 6 months on the I-864. They'll get their own separate I-864 later on. So another inconsistency right there with how the application for affidavit support is, and when you're doing follow the joint, on how that should be filled out. It's confusing and inconsistent right there. With regards to I-751s, the mess just continues, and it's a bittersweet mess. I just had a case we submitted, and unfortunately, for some reason, even though all over the application, the G28, the I-751, my cover letter, my address is everywhere, I didn't get a receipt for the application, and I contacted them. They said, we have your name, we have the city and zip code and state you're in, but we don't have the address information, so there's unknown in the application. I'm like, how's that possible? So I contacted them back with it through the online system. They said, because you contacted us within the last 30 days, we can't look at your case again. So I was waiting the 30 days to happen, and then last week in the mail, I got an AR-11 that said that the applicant's address had changed because they had moved while it was happening, but that we need to fill out a paper AR-11, and then at the bottom it says, if you already did it online, you don't need to do that. So I'm not sure why that was there, but it was mailed to my address. So they had my address in the system. Just another part of the inconsistencies that are happening throughout this. I never added myself as mailing address when I did the online AR-11 for the client. But as soon as I got that letter, I got online notification that the I-751 was approved. This was only after 7 weeks, a month and 3 weeks that I-751 is approved. It was a solid case. Client was really obvious that they were together. They had tons of bona fides, so we just included 100 pages of bona fides in there. But 7-week approval was spectacular. So with all that mess up with regard to the receipt, that was annoying. But I'm really happy to get a 7-week approval, and I have to wait, years potentially to get I-751 approved. So that's that. Now, one thing that's been happening, and I see this when people call me looking for an attorney a lot of times, they have attorneys that file the adjustment case, then for some reason they can't go to the interview. For example, the interview's in another city, or a recent one, the attorney got pregnant and they took a break, and they were calling me to try to find another attorney to come to the interview, and I was really shocked. As immigration attorneys, why leave it up to a client to go search for somebody? I mean, I understand finding someone in another state and recommending them could be a problem, but at the same time, if you know that you're going to be on pregnancy break, you should be planning this out ahead of time, what the client's going to do for an adjustment interview. Or if they're going to be out of state and you take a case out of state and you're not going to travel there, you should spend time getting to know practitioners that are good in that state that you refer them to, not leave it to the client in those last seconds start searching for lawyers. Now, some of these clients may have said, we don't want someone to come to the interview with us, and they change their mind, and that may be the reason. But I see it so often, it seems like our practitioners aren't focusing down the line of what's going to happen with the interview to prepare their clients for that if they need someone to be there. So that's something that's very important to do. I'm developing a directory that's hopefully come out. It's going to take a while because the directory is going to be intense, where I'm going to have immigration lawyers prove that they've done cases like this and work with them, spend a lot of time, see their approvals, almost like a certified kind of thing before they can be on the directory. But that'll be one location where you could find colleagues that have been practicing a while, have experience in a certain area in other states that you could use for consulting and referring to each other. So that's something that's going to be neat. That's going to be coming out hopefully sometime in the near future. One quick note is about a thing called satisfactory departure. When you come in on the ESTA or the visa waiver, it's a 90-day visa, non-visa really, where you can stay in the U.S. and you have to leave. There's no extension or change of status possible, but there is a thing called satisfactory departure when you could make a special request to stay additional short period of time because of some emergency situation that popped up in the U.S. So that's something you could potentially take advantage of, and there's a memo that discusses that, and there's more information on the adjudicator's field manual about that, but it's something to look into. One thing that I've been talking a lot in recent podcasts is about unauthorized employment and what it is exactly. And this has been a big issue with the modern economy where people are traveling and they're using their laptops to work. Is that unauthorized employment or not? One position I've seen CBP take a lot is that if the money for the work is coming from outside and it's kind of just quick work, temporary work or something like that, they're going to be okay with it. Really, the source of the revenue is bad. So we were at the LAX CBP meeting and talking with the chiefs of the CBP sections there, and discussing unauthorized employment because I'm trying to rationalize what the situation is. And they said they're actually going to talk to their legal counsel about the situation because for the Coachella Festival, they had a lot of foreign influencers who are coming in, and in their Instagram photos they take, they're endorsing products or being paid to come to Coachella and talk about it. But if the source of that income, for example, if Nike is paying them to walk around in Nike shoes, if it's Nike Japan paying them, it's fine. But if Nike, in Oregon or wherever, sending the checks, then it's a problem. In that kind of arbitrary kind of situation, when their audience is overseas, the work is overseas, but they need to travel for how the economy, the global economy works, and that's a problem. That's something they saw a lot during the Coachella Valley event that was happening, the concerts, and that's what they're going to be looking into. A colleague of ours and listener, David Telfer, sent a link to me when I was discussing this about from 9FAM 402.2 about still photographers, and it said that DHS permits still photographers to enter the U.S. with B-1 visas for the purpose of taking photographs, provided that they receive no income for the U.S. source. So again, the source of the income is highlighted here that it's a problem. So it's something to look at when someone's coming here to work, where that source of that income is coming from. Now, talking about CBP, there was a case I read in the news that was kind of sad. It was a girlfriend-boyfriend couple where the boyfriend was in England traveling here, and at CBP they checked his phone and he said something like, "I want to be with you, I want to live with you," all this kind of stuff, and they gave him expedited removal and really destroyed his ability to come to the U.S. without getting a 601 waiver, which can be really hard, and undoing that and fixing that stuff up. So that's something really nasty to be careful of when clients are coming here, that they don't have immigrant intent, they don't have anything that looks like that, they have their return ticket, they have life back home, and it needed in some ports. You can't communicate with CBP beforehand to let them know the situation. That, for example, I had a case where a foreign national was coming to the U.S. in the case I talked about, the London marriage, where, for example, getting married overseas is going to take too long, where the petitioner has to stay, more than a month. So I said, okay, get married in the U.S., but you get a same-day marriage for, on a vacation, a week or two break, and then go back home. I contacted CBP beforehand, let him know that they can't get married in the beneficiary's home country because it takes too long. He's going to come here, has work back home, has a return ticket, no intent. You got to double check with your client so you don't ruin your reputation. But he came, got married, left, and we have it on the record now that I did that. So if, constant processing later they had a problem, we can say, listen, we were above board. We always told everybody it was all good. Now this was a visa waiver case, so there was no interview at the embassy. But if they have a B1, B2 interview, they should also state that there of the intent. It's better to tell them there and get the tourist visa denied rather than come and have a later denial at the immigrant visa interview saying that you didn't tell us during the B2 that you were going to get married and you came back. That was misrepresentation. So that's something to be very careful of nowadays when dealing with DOS. In some good news, a colleague of ours in Los Angeles reported that he got a J1 2-year requirement waiver for a Fulbright scholar. Now, it's well known that Fulbright scholars have the toughest time to get their 2-year J1 visa requirement waived, but he was able to get it based on hardship because of the country they were from and how difficult it was for them personally and their careers to go back and have to do the 2-year requirement. It was approved, so hat tip to him to have that approved. Now, another thing that's happening is with the E2 visa programs. One thing is that Israel finally opened up its E2 visa program, and just some quick notes about that is Tel Aviv allows attorneys to be present at the interview, so this is an exception, but they are strict about what you bring in there with regards to electronics, even Apple Watches, and if you bring big bags. So because of the security situation, definitely check with the embassy's website beforehand to know what you could bring and what you can't. Another thing about E2s and really the spouse or L2s, the dependents of an EAD, really the spouse. On Form I-539, now that a biometrics requirement is needed, when you do file for an EAD with it, Form I-765, that has a fee for biometrics as well. You don't have to pay double fees. Or at least this is what our colleague Nadine H. Had told us because she had the same issue where they returned the I-765 saying you pay too much. The I-539 biometrics fee covered biometrics for both of them, so that's something to be careful for if you're submitting an application like that. Going back to the AILA liaison meeting with DOS and NBC, there was a comment that was made about E1s and E2s about having a storefront, and this is what they said. The requirement or necessity of having an actual physical store and space in the U.S. when you're doing one of these categories. It said, while there is no explicit requirement that an E1 visa applicant have physical premises in which to conduct business, the burden is on the applicant to demonstrate that he or she qualifies for the classification sought. A trader, or particularly a team of individuals without a physical presence or physical business office in the U.S., could face difficulty in demonstrating to the satisfaction of the consular officer that the enterprise is engaged in a substantial trade. It could be even more difficult for E2 applicants without a business. So that's something to look for. They also say to demonstrate the enterprise is more than marginal. Further, both E1 and E2 applicants must demonstrate that engaging in substantial trade or developing and directing a qualified enterprise is his or her primary purpose of travel to the United States. So you got to really show this kind of stuff. And also there's a note regarding 9FAM 402.9 about E2 investors and their derivatives. They're not required to submit Form DS-156E, but all E2 essential employees are required to submit DS-156E. And the department asked the mission in France and the United Kingdom to clarify on their websites at this issue and these points. So when you're doing it from France and England particularly, be mindful of the DS-156E requirement, but just in general for dependents and essential employees. Another interesting note that came out of the DOS A liaison meeting was about unlawful presence and how they deal with that at DOS and in the FAM. They made a note that if you get a stay of removal, you don't incur unlawful presence time in their opinion. So that's really important to know. Typically you have adjustment of case pending or change of status pending, you're not incurring unlawful presence, but they said that for stay of removal is the same. They also said TPS doesn't incur unlawful presence upon filing if it's approved and they have the status, so that's good to know. One thing I've questioned and talked with a lot of colleagues about is, what if a person entered unlawfully, had 10 years unlawful presence, then TPS was declared in their country, and they submitted and got TPS? What happens to that previous time before they got TPS? Is that unlawful presence? If they leave the country and try to come back, is a 10-year bar going to apply to them? So that's something to be mindful of. Now, if you have TPS and if you're in Ninth Circuit, that may be something you can adjust with, but again, that goes against 245C, having a previous violation. So unless it's a marriage adjustment case with a U.S. citizen, or INA 245K applies for an employment-based case, and they had less than 180 days unlawful presence, that might not be needed. But what happens with previous unlawful presence time? How would that be treated by the embassy? Something interesting to look for. Another final note on the liaison meeting is that AILA said they learned that there's a moratorium on designating new J1 exchange visitor programs across categories, and it seems like based on the new executive order, it's not new, it's 2017, the executive order for Buy America, High America campaign, they're cracking down on private sector employers for the J1, like camp counselors, interns, trainees, and au pairs, because they're trying to look into whether that hurts American jobs and the like. So that's something to be thoughtful of, especially if you're handling J visas. Now, just going back to the difficulty in the information flow from USCIS, understand, immigration is a big thing, but they should have people on top of this. If you visit the 245I page for USCIS, you'll see that they have unreliable information. They reference that you need to submit a G3258, even though that's not needed anymore. They reference that travel on advanced parole triggers the unlawful presence 3 and 10 year bars, which isn't true, and so that's going to cause a lot of confusion for a lot of people. A quick note of guidance, because I've been getting calls about this where people got bad information from other lawyers. If you're here on a B visa, particularly like a B2, there's a specific statute that says you're not allowed to go to school in the U.S. and it's a status violation to do so. So if you do come on a B2 and you attend a real school in any way, especially if you have children that attend an elementary school or high school, that's a violation of your B2 status. So it's not something you can just come with. You need to have an F1 for that. And you see this a lot happening with people. Sometimes they have, a U.S. citizen parent brings their child that doesn't have status and sends them to school. That is a status violation for the child to do something like that. Another quick note about mailing USCIS documents, and if the government says that the last day when someone can file something falls on a Saturday or Sunday or a legal holiday, the period of when that date, the deadline is the next day after that holiday is. So there's a little bit of time there. However, USCIS doesn't have a mailbox rule, so when you're filing, the date of filing a stamp on the post office is not what's final. It's actually the date that they receive it. So you should always mail stuff way beforehand. Even with next day mailing, you can't always rely on it, especially with the U.S. Postal Service. I've sent express mail stuff that took 3 or 4 days to get there, even though we paid more. So always try to build in a couple of days within there to keep it safe. Now, really, there should be litigation on this issue of how many days you have to file something, because as we know, the government says you have 30 days to response when they, for example, do a denial, and then they'll give you 3 days because of post. Sometimes the post office takes a week for you to get it, so you lose 4 full days. That's not fair. It happens frequently enough. So in these kind of cases, I do recommend that you keep the envelope that the post office, the envelope that the mail came in, so that you can later on challenge and say, listen, you said you mailed this on this day, but the stamp on the envelope was 4 days later, and by the time I got it, it was several days later. So you really ate up my opportunity to provide a proper response. If we have to document this enough, they force them to change their rules on this to add more days or do some sort of mailbox rule, so it helps us be able to get proper responses without having the crazy deadline and less days that are needed. Especially with the types of denial stuff that are coming nowadays that require a lot of time to prepare. One note regarding contracts and fee structures for your contracts. With the increase in delays, one thing that's happening for a lot of adjustment cases is that you need to refile for EADs and advanced parole because it's taking more than a year, especially with the backlog in the employment-based categories. Having seen that now, you should include in your contracts that renewals of AP or EAD will be an extra fee, so you're not hit with an hour to 3 hours extra work or hunting the client down to get documents just to do this and not getting paid for it. That's something to be mindful of. Also, a colleague of ours, Ida A, gave some good information. For those who employment-based cases particularly, but really everyone, when we request clients send us documents, most of the time, or more than half the time, they send us a good timeline. Within a month, they send most of the documents. But we all have cases where 90 days, 100 days go by, and we're still waiting for some documents, and we have to put the case aside, forget about it, and then the client finally sends a document, and we can't remember what the document was for. We have to go and spend time reviewing the file to see where it fits and the like. And she added to her contract, especially for EB-1A extraordinary ability, which is document heavy, if you don't submit the documents I need within 90 days, there's an additional hourly fee to review them, or the fee increases. And just to let clients know that this is serious. It's not something you just put on the side, especially for EB-1A cases where they get busy or they have issues. You have to give us this stuff because we can't just sit on it. It gets stale and we forget about it, or just we don't remember as finely what the points were, even with our notes, because we just haven't heard from you in such a long time. So that's something to be mindful of. Another issue that could happen, which happened to me, is when you send clients the forms to review. For example, you complete an application, you email it to them in PDF format. PDFs sometimes, Adobe PDFs, uncheck boxes or change the script on stuff. So when the person receiving it gets it, things will be different and change. I had a client who I sent, printed all the forms out, and then dropped off the signed forms in my office. But instead of, but unfortunately, the PDFs that they received had unchecked one of the boxes. It was the adjustment of status box of what their basis for adjustment was. And I took that and I reviewed things, and I missed that one box, but submitted it to the government, and the case was returned because we didn't give a basis for it. That was an I-130 with it. It was obvious what the basis was for, and a marriage certificate and all that, but they returned it, and I realized the copy that they had unchecked that box, but my copy still had it, the one I had on my computer. So I made mandatory now is that they only print, or if they want to print the whole thing, do it, but they only print to give me the signature page, and I only print my own copy, because I know my own copy has the information that I read on it, and just in case you miss something or like, just always print your own copies, and don't rely on the client's copies. Who knows, they might change something without even telling you, and you'll submit that without noticing it, if everything looks the same, they told you they didn't change anything. So make sure to print your own copies and not rely on a client's copy. So with that, I'm going to call it a day with the tips for practicing immigration law. Thank you so much for all the new listeners. Please go to the LinkedIn page, Immigration Lawyers Toolbox, and follow the page. Email me at info@jqqlaw.com, or if you want to join the QA Mastermind group and you're an attorney or a law student, email me at info@immigrationlawyerstoolbox.com. I'm going to enjoy having a conversation with all of you and connecting with all of you. So with that, have a great one. Bye-bye.